And then share screen. So tonight we're going to be going over the basics of planning board. Now, there are two things I want to just quickly clarify before we get into this. One, while we do not have someone from the Maine Municipal Association here to go over these items, I have gone to their courses before, and I'm trying to do my best of taking whatever they have taught me and give it to all of you tonight. If you do want the MMA certification, you can always go to the Maine Municipal Association meetings. This is supposed to help as sort of a fill-in period until there is a meeting that's better for your times and schedules, but we are going to go over a lot of the material they go over so that you're at least aware of some basic procedures and best practices you should be doing. So
and this will cover everything except what was that one area?
Board of Appeals?
Yeah.
Yes. We're briefly going to talk about Board of Appeals for a moment, but I assume everyone here is with the planning boards for their respective towns. There's no one here on the Board of Appeals. Put your hand down.
Oh, yeah.
Really?
Yeah, I'm in French Bros Board of Appeals.
Overachiever. All right. So other than the one person here, this is going to focus on the planning board materials, just what a planning board is, and how you should conduct yourselves before, during, and after a meeting. And we are going to have periods in between each for you to ask some questions so we're not forgetting the topics. I'm sorry, you have a question?
Yeah, I had a question, because you mentioned it's based on MMA, but you don't give a certificate. Does MMA provide certified training so that you're considered a certified planning board member?
So no, so you do not have to have the MMA training to be a certified planning board member. It is just MMA going through all of their materials as well. A lot of the same materials that I'm doing here tonight, and they'll just have a certification to say you've taken our course. Pretty much. That's
not like not like a testing process. Or
no,
that says you're
no,
bona fide.
No.
Thank you.
Right. So with that said, we will get into this. So tonight I am going to be going over, as I said, the basics. I'm going to briefly discuss the Freedom of Access Act because there have been some updates to that you should be aware of as planning board members. And as I said, I'm going to go over the procedures for how you should review an application before, during, and after your meetings. Just some general suggestions and best practices that I'm at least recommending. You don't have to do them. And then any state standards or rules, I'll be going over those tonight. And then Avery and I will go over some future workshops that either of our groups will be doing in the next month or so. And throughout this period, we are going to be having some questions and answers. So when I go through the background of the planning board, I'll give you a chance to ask questions about any of that. And same thing when we get to the during meeting procedures, after meeting procedures, we'll give you a chance to ask questions in those different periods. So the basics. Planning boards are responsible for applying, and I should add one more thing. The slides will be available, so you don't have to write down every single thing that's up here. Just try and pay attention to the things that you think are important, and we can give you the slides later. And the meeting is being recorded, and you can watch the meeting afterwards. So planning boards are responsible for applying your local ordinances and standards that are approved by your municipality through impartial review. Decisions must always be based on that information and what is presented at a public hearing. If you don't like the standards that are in your town, you will work with your town to amend your ordinances in that case. You shouldn't be doing things based on your own personal feelings or what the public has requested. A planning board must be created by members that are sworn into office. I assume most of you are appointed by your select boards. There are some towns that have elections for planning board members. All that is determined by your local ordinances and your bylaws. Same thing with the number of planning board members and the alternatives that are created. If you wonder if you have a 5-member group or a 7-member group, you need to reference your ordinance and see how many, and even if you allow things such as alternatives. Ordinance interpretation is the responsibility of the Board of Appeals, but only upon a formal application. It is not by a request by the planning board. So until that time comes, you are the ones responsible for that interpretation. Your best practice is to try and have something that's consistent and fits with the context of the rest of your ordinance until there you do have someone who wants to challenge that interpretation. Planning board chair or chairman, depending on your local ordinances, is a office position that is decided on your local ordinance procedures. Many towns will just have a once-a-year election after new members have been sworn in to simply determine who will be the chair of your board. They are responsible for being the moderator of your planning board and keeping everyone engaged and focused until the end of the meeting, which I know that's a big task. Trust me, once we get past 2 hours, I'm almost out of it at the end of the meeting, and you'll see that tonight. And the other important task for the chair is to be able to bring conversations back to the application and to make sure any sidetracking ends. Again, something you're probably going to see tonight with me. If I sidetrack, feel free to be the chair tonight and tell me to get back to the presentation. Now, the Freedom of Access Act is something you should all keep in mind. This is a state law regarding public records and proceedings. Planning board members are actually required to take a Freedom of Access Act course within 120 days of their appointment or their renewal. This is something that was updated to have this requirement, I believe, in 2021. And there are courses that MMA does offer, and you can also speak with your town attorney who may be certified to also teach you that as well. This is a process where if you are asked by a local resident or just anyone from the general public to provide documents, you must provide those in a timely manner. And this is any written information. This can be the application itself. This can be any planning board material such as your minutes or your agendas. This is also emails, written correspondence that you have with your own planning board members. And any handwritten notes. I see some of you doing some notes tonight. If there was a member of the audience who wanted the Freedom of Access Act, they could certainly ask for those notes. So keep it clean. And just any information from the applicants will also become public information. So if you have someone who wants to build a basic deck and they're giving you an application, say, but I don't want that piece of paper, that's sensitive information, I don't want you sharing it with anyone. It's advised you tell that person once it's in the town's hands, it's subject to Freedom of Access Act. And if someone wants to see it, they get to see it pending legal review by your town attorney. Now, if you do ever get this request, take a breath, talk with your town clerk or your town staff and explain to them this process. They may have their own process where a form has to be filled out, or they have a certain policy or procedure that gives you a few days to fulfill this request. So talk with your town clerk if you have any more, or town manager or town administrator if you have any additional questions about this, and speak with them as well about trying to get this certification. You had your hand up. Did you want to?
Two questions.
Right.
The first one is, you said the course is a mandatory requirement. I assume this is state.
Freedom of access is, so I'll also repeat the questions just for the recording and for people online. So the question was, is this a required course? You do have to be certified in knowledge of Freedom of Access Act. And that does have to take place within 120 days of either your appointment or your renewal of term. And that was done in 2021.
Okay, now, if you're not, what's
the state's been interesting on not checking in with towns. So the penalty would be more of when someone actually, if someone approaches you and wants to do the Freedom of Access and you don't follow through with it, then it's just going to be people wondering where your certification was.
as about records, all these records and notes and everything being available? Is there a time limit on that as far as record retention?
Is there a time limit on record retention?
Yes.
So you're talking about your personal notes.
Emails, minutes, agendas, anything that's generated by a planning board. How long do we need to keep?
How long do the planning board members need to hold on to these documents. Usually the town office should hold on to at least the applications, the minutes, the agendas, a lot of the basic planning board materials, your personal notes and everything. It's hard for me to give you an answer on that because if it's a scrap piece of paper, it might not be anything and no one might ask for it, but I can't give you a good determination on that. And that's a question you would probably want to talk to the attorneys about.
Can I interject briefly with the training? It's not as onerous as it sounds. I think just reviewing a document they have on their website is considered sufficient. So I have staff and planning board members review that and sign that they've reviewed it.
Okay.
Thank you.
This is Catherine. Could you, somebody give us a link on how we can do that? Because our town clerk did not list me as a planning board member, and therefore I was not allowed in to take the course.
Oh, it's not really a class. It's a public document on the MMA website. As long as you may have, I don't even know that you have to have a login to see that one, but anyone on the staff who has that can print it off for you. It's a couple pages.
Yeah, I'm seeing some head shakes that it is a public document. You don't have to log in or anything. And
Thank you.
Avery's taking notes. She'll send a link out after this meeting.
And I'll add too, most town clerks would know that there are document retention requirements for different kinds of documents, and the clerk should have that list about how long different things need to be retained.
So speak with your town clerk. All right, so moving on. Then there's the notices and advertisements. This isn't something that you personally will be dealing that much about. This is going to probably be your town clerks and your town staff. All public meetings must have a notice posted that can be observed by the general public. How that is done is dependent on your municipal charter or your bylaws. If you do not have one, then at least posting on your website, putting an ad in the local newspaper, some way of just having it out for the general public to see. That's what MMA is at least asking for in best practices. Now, there is the one requirement, even if you don't have a charter, you are required to at least notify abutters whenever there is a subdivision approved or a subdivision review, regardless of what your application, regardless of what your charter or your ordinances say. The notice shall be given in ample time to allow public attendance and shall be disseminated in a manner reasonably calculated to notify the general public in the jurisdiction served by the body or agency concerned. That is from the state statute. So personally, that for me, I always look at 7 days, at least a week. I'm only speaking on my own personal preference here. If you have a newspaper that runs an article the day of or the day before your planning board meetings, try and have it posted in their newspaper the week before. And if you do have a website that a lot of people visit, post it on the websites. If a lot of people go into your lobbies in the town office, post it in there. But don't just post it in the underground basements, the 2 doors behind the bathroom, and expect everyone to go there, because that's probably not a well visible area. And again, this is my suggestion, but I feel posting the agendas and the minutes and the applications on the website, although they are not required, I feel that is a great way of also getting the notices out to people. Because one of the calls I will get all the time is, well, when is this application happen? The agenda's on the website. Well, what's in the, what's going to be talked about? Well, you can see the application materials online. Well, what was discussed last meeting? You can find those materials online. It's a way of at least getting it off your shoulders so you don't have to spend so much time repeating the same points. And if everyone just goes to the website, they'll get used to it and they'll see all the documents online.
Boy, you're gonna get tired of here. Is there a format, a prescribed format for agenda and minutes?
So a format for agendas and minutes. Actually, that the agenda part will be a bit later in the meeting.
Okay.
And for the minutes, it's always up to your secretary or whoever is going to write those minutes. The question was if there is a standard format for agendas and minutes. And we'll get over that. We'll talk about that in just a bit.
Okay, thank you.
So before the meeting actually starts, applications shall be provided to planning board members in a reasonable amount of time to review the materials. Again, I suggest 7 days, give you at least the weekend to look it over. So you may be sad that you lose out on your Saturdays, but you know, sometimes it's rainy outside. You need something good to read. If your municipality does not have a standard or a procedure for this distribution of materials, I would work with the town staff to start creating that process. I doubt many of you want to get all these documents right at the meeting, and then you're spending more time just reading through everything, not having a chance to also compare it to your ordinances and your standards and make sure you had time to digest the materials. An application may not be considered incomplete until the meeting. Board members may not directly discuss these issues they have with the application or with the applicant themselves outside of a public setting. So if you were to get all the materials, you shouldn't be speaking amongst yourself saying the issues you have with everything, because that might be considered a private meeting by some people. And at least when you get to the meeting itself, you'll be able to air your grievances about the application at that time, any questions you may have. And as noted earlier, it is the public discussion for when you should have these types of meeting or these types of discussions.
Max, is that an application for subdivision
so-
approval or?
It's all right. I will say though, we are gonna have in 2 slides a chance for you to ask any other questions up to this point, but I will answer that. The question was if this is any application materials or if this is just subdivision approvals. In general, this is Freedom of Access Act related. You shouldn't be having private meetings talking about the applications either with amongst yourselves as board members or with applicants. And when you get the application, the ample amount of time is for any application that you, the planning board, will review. Does that answer your question?
So in the case of like Monroe, the only applications I know we address are subdivision approvals, that's it.
Right.
So in our case, that would be the extent of an application.
If the planning board in your community is only reviewing subdivisions, then yes, that would be something. As long as your ordinance spells that out, then yes, you should be getting those materials in what you consider an ample amount of time. If you think if there is no time limit, you should work with your town staff to say, you know, I need X number of days to start looking at this, and the planning board as a whole needs to make that decision to review the materials. If everyone's fine with reviewing it the day of the meeting, then that's fine. That's your decision. Right? All right. And just one quick point I want to make about planning board members discussing things outside of a public meeting. This includes one-on-one email discussions, or not one-on-one, but email threads amongst your board. This includes phone calls, even an unintended bump in. If you bumped into someone here tonight where you're on the same planning board as them, I hope none of you are talking about any applications coming to you in the upcoming month, because that is one of those issues that we don't want to encourage. So at the beginning of the meeting, you must determine that you have a quorum, and this is 50% plus 1 of the number of members that you have, depending on your local ordinance. So if you have 3 members in your ordinance, you need to have 2 members. If you have 5 members, if you have a 5-member board, you need to have 3. If you have 7, you need 4, so on and so on. And it's all right. The chair is responsible for calling the meeting to order and to verifying this quorum. And obviously, if the chair is not there, the vice chair will take responsibility of that. And if there is no vice chair nor regular chair, you should probably determine as a first action item who should be leading your meeting that night, although it's very rare sometimes to have that case. Now, to answer your question from earlier on the agenda items, everyone should have an agenda. It's a good way of keeping track of your meetings. Robert's Rules of Orders is something that some people will use by default, but it is not a required standard. It's really however your planning board likes to go through the meetings, whether you want to do approval of the minutes first or last, or if you want to have the site plan that you think is going to take the most time done last, or if you want it done first. Really, it's dependent on how your board would like these agendas to be written out and what format they want to do. Does that answer your question from earlier, if how agendas should be formatted?
No, right, yes.
Well, so quick check-in and questions on where we're at so far. I do see one hand out.
I want to follow up on the question here about applications, but you've been referencing the applications. I have to say, most of our meetings have nothing to do with applications.
Mhm.
We may be discussing the comprehensive plan. We may be discussing revisions to the land use plan. So I'm wondering how much of your comments reference these other types of meetings that don't have to do with the really specific application, like the forum. Is that also required? Any, like,
Whenever you do hold a public meeting, I'd say almost everything we've talked about so far still should fall under that, guys. Even if you're talking about comprehensive plans, updating your local ordinance, any planning board matters, those are discussions that should take place at a public hearing that has been advertised, because you
advertising in the newspaper?
or however it's done in your local ordinance. If you just post something in the town, on the town calendar that says you meet every second Tuesday or Wednesday or whenever you meet,
That would be sufficient.
yeah, that would be sufficient. Well, again, it depends what your local charter says. If you don't have anything, posting on the website would be fine.
Yeah, we don't have any-
But- That's fine. So the question was if, how much of this is applicable to non-application planning board reviews? And just to repeat the point, you should still follow the Freedom of Access Act and proceedings and hold public discussions at a public meeting that has been advertised in some way, depending on your local ordinance. Any other questions? Comments? All right. Then we'll move on. So this is going to continue being an application now. So a lot of this is actually going to still focus on applications. I don't know how much is going to fall into ordinance reviews or anything like that. So getting into the application itself, is it a planning board matter? The first thing that should be confirmed is if any members of your board have a conflict of interest. This is if you determine if a member of your planning board is either a relative, a business partner, a good friend of the potential applicant, or if a board member may be directly impacted by said application. This could be someone whose property values are impacted. This could be someone who's just been very vocally against something out in the public. Those are matters that could be a conflict of interest. And how you do it is the planning board will have to vote to determine if there is a potential conflict of interest. Usually a good practice is a member who just knows that they have a conflict simply says, I believe I have a conflict. I should recuse myself. Will the planning board allow that? And the planning board then acts on that motion. The next thing that should be determined is whether the planning board even has jurisdiction on this. So this would be reviewing your local ordinance to see what allowed uses are in your community. And then if the planning board has the right to authorize that. So if we're going through, say, the shoreland zone, you have your different zones for what the code enforcement officer reviews versus what the planning board reviews. And then you have to see if the application has standing. So the person who is submitting everything, do they have a deed, a lease, a title of interest, any document that verifies that they have permission to submit the application? Now, covenant and deed restrictions, I know this is going to sound weird. Covenant and deed restrictions are not something that you will review at this time when it comes to an application. That would actually come a bit later, since that is more of a civil matter item. The next question is the application complete? So again, skipping the covenant and deed restrictions that you may see, the board has to determine if the application is considered complete and and you may still request more information. So go through your standards, any parking items, any screening, lighting, any concerns you may have in your standard, you go through those standards, every single one, and you have to see if the applicant has addressed it in some way, shape, or form. And if you don't believe they have addressed all those, you as the planning board have the right to simply say, we need some more information on this, or we need some clarity on this. And these are all items that the planning board has to go through and should confirm. Now, when you're reviewing your application, always remember the applicant bears the burden of proof to show that they are addressing everything that you need them to address. And it is up to you to determine if you believe the evidence is credible and relevant based on your discretion. And how you get it can be done in many ways. You can designate someone from the town staff or even a board member to reach out to the town attorney or any state agency that might be applicable to see if they can give you some insight on the application. This also includes reaching out to the Maine Municipal Association's legal team to just ask them a zoning question as well. They are a great resource, I'd say, for any town that has these types of matters. Boards may also choose to conduct site visits as long as you don't violate the Freedom of Access Act and publicly advertise those site visits as well. We will get into that in a little bit. The boards can also rely on your local knowledge and experience if it is applicable to the ordinance. So if you have an individual who wants to build a childcare place, and you have one board member who remembers growing up and loves playing around that area, but probably should have someone check to make sure all the fuel tanks were actually removed from the former gas station before having a playground there, that's relevant to the conversation. But if the board member starts going on a 5-minute rant about something happening in the national news that has nothing to do with the application, the planning board chair needs to start reeling that person back and saying, what does this have to do with the application exactly? And you also don't have, the expert opinion by the applicant does not necessarily mean it is accepted. You know, that sounds a bit weird to say, but if the individual is, say, from a state agency and they're saying, well, I'm from the, hopefully I don't get in trouble for saying this, well, I'm from the Maine Department of Environmental Protection. I don't think I need to do any of these permits that you think I have to do because I know exactly what I'm talking about. They get a great benefit from having the application approved, so they do have some bias in that, and you may decide you want a third party to review that instead, because even though they are an expert in their field, there's a chance they might just try to skirt that expert knowledge for a moment so that they can get their application just done as quick as possible. So never feel shy about asking for a third party, even if the person says, I know exactly what I'm doing. They also know how to get around you. And you can also make sure that the CEO or code enforcement officer and any other town staff members help weigh in on this application. However, if that's happening, make sure they have it in writing or they attend your public hearing session so that they can speak on it, again, during a public hearing. Because then we get back to the Freedom of Access Act and how someone's going to say, well, how is this determined? The code enforcement officer can back it. Well, where's the proof of that? That's what's going to be asked. Now, we talk about the deed restrictions and covenants from a moment ago. When you get to this point, you do have 3 options how you want to address it. An application may be, if you are concerned that someone's presenting a deed saying, I'm allowed to own and develop this site, but then you have an applicant turning around and then you have a neighbor saying, well, no, this is my deed and it says the exact opposite of it. You have 3 options. The first is, because it's a civil matter, you may choose to table it at this point until the civil matter is resolved because you don't feel confident that the person has all the necessary paperwork to continue. You may deny the application because you don't feel the burden has been met, or you may decide to approve it on the condition that the location as presented is accurate and does not constitute any property disputes. So if the person just turns around and says, well, now they've approved it, so that means I do own the place, your condition of approval specifically states, no, we allow it as long as you can settle that civil matter first. I don't recommend doing that condition of approval, I would suggest either tabling it until it's settled or rejecting it until they do have an updated deed or easement. And as for members that you're gonna face this for any long applications you may have, if there is one particular member who was absent for the first meeting and you're now 3 or 4 meetings down, that individual can still participate, but you should consult with your town attorney and possibly see if the applicant may give a blessing at the public hearing, just because the attorney may just wonder if there's any issues with how knowledgeable the person is on the application at this point. And the applicant may feel that, you know, we're 4 meetings in, why is this person now being brought in out of the middle of nowhere? It's a rare circumstance you're gonna get, but just keep that in mind if you ever do have one of those instances. Now, the site walks or site visits that I just mentioned a moment ago, they are not required unless your ordinance says otherwise. But if you do ever have one of these site walks where someone's talking about how they're gonna build this massive solar farm and you're curious, well, how many people can see it from the edges of where you're proposing it, and you wanna conduct this, that is within your power and responsibility, because again, you're allowed to ask for any of this type of evidence. You do have to follow the same public hearing procedures as the freedom of access was outlining earlier. So this means you post something in your town office, you put the ad in the newspaper, you follow the exact same things, and you treat this like a meeting. But you don't approve or make any agreements at these site walks either. So this is just a data gathering exposition where you just learn more about the site. Now, you may get an instance where the applicant doesn't want a site walk, but you do. It's up to the applicant to try and come up with an alternative that is satisfying to the board members. So they may decide to give you some aerial photos or some on-the-ground photos or a recording of the site of them walking around it, because maybe it's a danger and they don't want anyone there. Maybe they are very scared about having other people invading their privacy. You never know. But it's up to you. And if you say, no, we need a site visit because we don't feel confident we can accurately do this without, then that's going to be something that the applicant has to address. And finally, the board must determine all standards and criteria that are applicable. Some towns will have specific ordinances, and you may have some standards that say a restaurant needs to be hooked up to us. If you have sewer and water, the restaurant would be hooked up to the sewer and water system if it's within a certain distance. Or if there's a playground, you have to make sure that the children or the play area is outside a certain distance. So you determine if there's any specific standards for that. And you'll probably have cases where the applicant says, well, I would love to have this vegetative screening along the road frontage of my property, but I have to get this permit from the DOT, and that's now a conflict. I can't give you that buffered screening and also satisfy what the DOT wants. And so you may have that power to give a waiver, which is essentially saying you aren't going to require that one standard to be applied to this application. How the boards are able to give waivers sometimes are up to local ordinances. Sometimes there are some standards that you may not be allowed to give a waiver to. Sometimes it's just a matter of the planning board saying together in one motion, we are going to grant a waiver to this individual because reasons X, Y, and Z. And then after you have gone through the application, there is a citizens and public comments moment. Now, because of freedom of access, you must grant a time for the public to comment on these applications at some point during your review. How you determine that time is up to you. You can have them at the beginning, you can have them at the end. It's whatever procedure you are all comfortable doing. The planning board and the applicant are not required to respond to those public comments. Someone may ask a very personal question of the applicant, and the applicant may just not want to respond. Or The applicant may be asked a business question and decide they don't want to reveal that information. That's within their right. Same thing with the planning board. Someone may be asking a question that has nothing to do with your application review, and you can just simply say, noted, next question. The planning board may also impose restrictions to keep proceedings on track. I always love talking about how I love to ramble. You'll probably get that in these public comment periods where someone's going to go on a 5-minute rant that has almost nothing to do with the application, and you just need to tell them, we have a meeting tonight, we need to get to the application. Can you please ask your question or your concern so we can get to the other comments? And the planning board chair is still responsible for keeping things on track. So just like how the planning board chair may interject when a planning board member goes off track, the planning board chair will also get involved if the audience starts getting off track as well. Now, under the Freedom of Access Act, the public is allowed to attend the meeting regardless of their residency, and they're allowed to take recordings and notes of those meetings as long as they're not being disruptive during those meetings. So if someone here tonight was pulling out a cell phone, that's your full right to do so. I'm not going to stop you. But if you start getting in the way of other people, if one of you wants to jump in front of Avery and start putting a cell phone right up to my face, that is disruptive and you can be asked to leave because that's distracting to the entire meeting. Hope you're all right being used as an example. After reviewing the application and after holding the public comments, if there's no other concerns, you'll get to the voting. Again, unless there's a conflict of interest, all board members who are attending that night should be prepared to vote. If that means, even if you went to the bathroom for 5 minutes, you're coming back and you need to be caught up to date on the application for those last 5 minutes, because you're going to be voting yay or nay, regardless of whether you feel comfortable voting that night. Each applicable standard must be reviewed by the planning board to determine that the applicant has satisfied the requirements. I'm going to say it again later, but I highly recommend having a checklist going over all of your standards, just because it's a good procedural item to just know every single item for every single application and just checking the boxes, making sure you didn't miss anything. Unless specified in the ordinance, a majority decision is based on a majority of all members of the planning board. So if you do have in your bylaws or your ordinance a planning board that consists of 7 members, you will need at least 4 votes for the approval, even if only 4 members of your board are in attendance that night, if that makes sense. So if you have a planning board that's supposed to be 7 members and you have 3 vacancies, you better hope all 4 members attend every single meeting and all 4 members have one great hive mind of agreeing on these things. And a tie vote is going to be considered a failure to act on the motion. Finally, any votes against an application should be because of a procedural matter that was not followed, the applicant did not satisfy any of the standards, or you do not believe there was sufficient evidence to back that application. Voting no or abstaining strictly due to a public perception is not acceptable. And I'll add on to that if you are voting no or abstaining, a best practice I follow is having it reference where in the ordinance why you are going to vote no or abstain. So if you do not believe a parking requirement was satisfied and someone made a motion to accept the application, you would say, I vote no because I don't feel the parking requirement was satisfied. And I just do that just so the minutes are able to keep track of it. And so the applicant then has a chance to try and address it in a future application. And we get to the conditions of approval. 2 more slides, I swear, then we'll get a quick check-in period. Conditions of approval are possibly one of the most important things you can have when you're reviewing your applications. This is the chance for the planning board to add any additional reasonable items onto the site plan that require an applicant to address a standard that can only be done after the approval. Because you'll get those cases where it's an undeveloped lot and the applicant says, well, I need to get all this done, but I want to make sure the town's fine with me doing this first before I spend tens of thousands of dollars. This is your chance to say, okay, we will give you the permit, but you still have to make sure all this stuff is done even after you're completed with the project. And all conditions that you are doing must be based on a standard or criteria that is in your ordinance. I'll go back to the parking example. If an individual is saying that they can only provide one parking space because their proposed use isn't going to have more than, it's just going to be, let's say, a senior retirement facility, and it's not going to have that many people driving anyways, so they only need one parking space instead of two parking spaces per unit. You should have a condition of approval that specifically states that they're allowed to have less than one unit, they're only allowed. We can't talk tonight. This is what I'm talking about. You get into a night meeting and you start losing it. You can make a condition that says, well, we'll give them the one parking space instead of two, but that's assuming they only are doing this elderly living facility and they're only going to have this and they're only going to have that. So that if they go back on that condition, if they then decide 1 year later, oh no, I'm not going to actually do that idea anymore. I'm just going to build this multi-million-dollar condo complex instead, and everyone's going to have 3 cars. Well, that completely lies about what they were even being approved for. The conditions of approval must be part of your motion for the public record. So if you make 5 different conditions of approval, the planning board's motion should be to accept the application with the following conditions of approval, and then you outline those conditions. Conditions of approval must also be written on the site plan that is signed by the planning board and a separate written decision. And I'll just add a note that if the board threatens to remove the permit if the condition is not met, that should also be a condition. I have actually just recently had this experience, very similar to that example I just gave, where an individual on the cover sheet said, I'm going to be doing an elderly focused facility, so 55 or older, so I don't need to do most of the standards you're asking for. The planning board approved it, but they never specified on the conditions of approval that it was going to be for people who are 55 years of age or older. And so the individual came back 5 years later and said, well, I'm not going to do that anymore. I'm just going to let anyone there. And the town has been told by the attorney, you didn't have that as a condition of approval specifically outlined in it. So unfortunately, you can't enforce that item. So that's how important it is. Even if it seems obvious, if there is a very important item brought up by the planning board or by the public, make that a condition of approval because you want to have that backing. A common condition that a lot of applicants will have on their final approval is simply proof of compliance of all state and federal regulations through approval or a letter that will be filed with the town office. If you have a business that's opening up on a state road, they're going to have to get a DOT permit anyways. So just for your files, just to have it on record, it's best that once they get the DOT permit, they're with your town files as well. Same thing with DEP, or Department of Environmental Protection, if someone's going to be building more than an acre, or they're going to be building in the shoreland zone, have something from the state agencies as a condition of approval, just so even though you've done your homework, you're aware that the state has also been involved in this process as well. Now, for all I'm talking about with the conditions of approval and waivers, one item to keep in mind is that a variance is not an acceptable condition of approval nor waiver. Now, a variance is when you take the minimum lot size standards that are in your ordinance and you give permission to that applicant to have less of a setback, less minimum lot sizes. I should actually have Dan over here talking about that if he's on the Board of Appeals. You don't want to talk about that?
It's a very fine.
I'll get there, as long as you don't have an application yet. And this is going to be something where you may be asked by an applicant, well, I can do all this stuff, but I see that your road setback is 50 feet from the road. I can only build my stuff 20 feet from the road. As the planning board, you will essentially have to say, well, that's unfortunate, you need to go to the Board of Appeals to get that setback approval. And that can certainly be a condition of approval that you could make a condition of approval that the individual is allowed to do it as long as they get the variance from the Board of Appeals. Personally, I wouldn't encourage that because sometimes it's a pretty big ask to get a variance in the first place. So usually someone should go to the Board of Appeals first to get the variance. And I know one more slide. When making a final decision, you should create what's called a written findings of facts and conclusions of law, which goes over your decision. Avery, do you mind if you just pass this out to everyone? So what everyone here is being handed is a draft example that the city of Augusta uses for their findings of facts and conclusions of law. It goes over just what the current uses of the site, any permits associated with the site, what it is zoned as, the acreage. And I need to cheat and look at the very thing I passed out, the tax maps and the zoning, the actual owner of the site and the applicant, because it might be different, a description of the project, and how the town followed the Public Advertisement and Freedom of Access Act requirements. And then the conclusions of law is the planning board acknowledging that they've reviewed the criteria, they've reviewed the standards, and they believe that they have followed everything to the letter and approve it as shown or with the conditions of approval. These are very important documents to have, especially if there is ever in a case where you are being appealed on your decision. You may have the most detailed minutes in the world. Those aren't going to be accepted when it comes to an administrative appeal with the Board of Appeals or the Superior Court. They're going to want to see the findings of facts, because this is going to be the summary that goes over the actual applications and everything that the planning board unanimously could agree they were reviewing. Now, the planning board may designate someone to put this together. You don't have to do this during the middle of a meeting. You could have a staff member or you could have a volunteer planning board member put this together. However, you need to be sure that once it's put together, the planning board reviews it, say it with me now, at a public meeting, and reviews it at a public meeting. And now, just a quick check-in I know there's a lot of stuff that I threw out there, so let's start getting some questions out there.
Okay, so you mentioned that there needs to be a motion to be voted on by the board. How is that different from this document? Because at the end, it seems to reference that if this document is to go forward. So this the document that's being voted on by the planning board?
So the question was if the findings of facts and conclusions of law would be the document for the planning board to approve. The example that I gave you in Augusta was a case where they give authority to their planning board chair to sign off on this document for public record. Your whole planning board may decide to have a slot for every single planning board member and not just give that power to the chair. I guess your question was also about there essentially being two votes, one for the application as a whole and then one this. So the findings of facts and conclusions of law is meant more for administrative record keeping rather than just the application that night. So, or a summary sheet. I love to kind of call it as a summary sheet for the planning board members so that you understand what you are voting on. I know everyone's going to have the binder full of the application and you're expected to know every single thing that's in that binder. And I know all of you are speed readers who probably finish that in a good minute and memorize every single detail. But this is meant more for the people after you. 10 years from now, if there is someone who is going through the documents, going through the records, this is probably what they're going to look at in case that binder is somehow missing and see this is the information at its core, what you are approving.
Would they look at the motion that was voted on? And what would the difference be between that? Like you said that the motion had to be written up. It had to be written up before the vote takes place. It can be written after.
You could do like the timeline for when to do the findings of fact.
No, so you've had all the hearings. It's time to vote. on the budget. You said there needed to be a motion that was voted on to approve, or not, and if that needed to be written.
Okay. So
I understood you correctly.
so the question was having the planning board do a motion to accept or reject the application.
And when should that be written?
When should that?
Before the vote or after the vote? What do you think?
Findings of facts, I would say maybe done after, but you can do the motion to say, it all seems fine, so you're 90% done. I know I'm kind of rambling on that motion, but you would essentially say for that meeting, we approve the application, you can at least get some stuff started, and then the next meeting, you're voting on the conclusions in law or findings of facts. Although again, maybe your board would be more comfortable doing the public review and then waiting 1 month, making sure you're digesting all the material, and then voting on the findings of fact the same night you want to approve the application, where you'd have your understanding before leaving that public hearing. This is all the information we're aware of, and if we are going to do a findings of facts and a conclusion of law, what are the conditions of approval we want to have met that we want to make sure are in the document?
I just imagine a situation where we voted to approve project in the motion. And then when it came down to writing this and reviewing it, we realized,
We missed something.
this.
Right.
We missed something.
Right.
What happens in those circumstances?
If there's a circumstance where you're now writing the findings of fact after the approval, I can't speak for every single ordinance. Some towns will have a reconsideration clause for the planning board, especially if they miss something here. If you don't have that, then I would probably recommend having the findings of facts written up first.
Part of the question, you mentioned that there's a distinction between a waiver and a variance.
Yes.
How do you tell which one is needed for a certain condition that's in the ordinance?
Usually that would be something in your ordinance itself. The state of Maine also outlines the Board of Appeals and variances in their state statute as well. And variances are typically setbacks, minimum lot size coverage, minimum lot sizes in general, dimensional standards essentially. Because at least at the state level I know we're getting into Board of Appeals items here, but at least at the state level, what they just require for variances, they are single families, someone taking an undeveloped lot and they just want to put a single family home here. So that's why they need the variance. You have someone who has an ADA accessibility issue. You got to get the ramp out there for the wheelchair accessibility, but now it suddenly violates the setback. There is undue hardship. If someone can prove that if they can't do what they want to do, they are out so much money that they have to do something on that site, which has become a bit more challenging to do because even as an undeveloped lot, someone could turn around and make the argument of, well, all you have to do is just give it to the land trust and now it's a use. But the variances are all outlined on the state statute. And if you ever have questions on what is an applicable variance, I would recommend talking with the Maine Municipal Association. But as for your standards, that should be outlined in your local ordinance. Any other questions so far? This can be about what happened before the meeting, during the meeting.
I have another question.
Yep.
You said that site visits have to be publicly announced. I'm assuming that means that anyone in the public from anywhere who decide to show up to that site visit and come with you on to
Mhm.
the property and the property owner. You have to pay you have to get the property owner's permission first to do the site visit and inform them that this could mean that the ravening forest is going to come on their land.
So the question was, do you need to get the site owner's visit to do a site visit for an application? Best practice that I always follow is having it discussed at the public meeting to just try and outline that, first asking the owner of the property if they are fine with a site visit. And if they just say at the meeting, no, I'm not comfortable with that, then it's up to them to then give some alternative solutions. And if the planning board and the site owner can't come to an agreement, then it goes back to the planning board of, well, do you need the site visit to determine it's all credible, or can you approve the application without the site visit? But you do need the site owner's blessing to do the site visit. And it's also advisable to tell them when you want to do a site visit. Keep in mind, we have to send out notices. This could mean anyone from the public's here, but it doesn't mean someone can come from the public and wander a 100-acre lot. They have to stay with your group. Any other questions so far? Only lost one person so far. So now we have approved it. So what do you do after the application has been approved? Unless the bylaws have specified otherwise, you should make sure that at least a majority of the planning board or an authorized planning board member has signed off on these documents. I go back to the findings of facts and conclusion of law example I just gave. This was a case where the planning board chair is allowed to sign off on these documents if approved by the planning board. If there's a case where all the planning board members are signing it, signing the applications or the documents are not an admission of approval. They are acknowledging that the vote has taken place. So if you have a one planning board member who is voting against an application, let's say it's the chair. If that chair then had to turn around and sign all these applications, his vote didn't magically, or her vote did not just magically turn into a yes. It's the chair acknowledging that I was outvoted, majority did vote this, but this is how I voted on the measure. A copy of the signed site plan must be kept on file at the town office. This gets back to the Freedom of Access Act. And a copy of an approved findings of facts or conclusion of law that I've sent out to you should also be kept on file with the town office. Again, if 5 years from now, none of you are still on the planning boards, I know there's going to be a lot of sad town clerks at that point, but if none of you are still there to answer any questions and someone's asking about this site, they're going to have to use whatever written documents are available at that time. Unless otherwise specified in your ordinance, only the Board of Appeals may attempt to remand a planning board decision. This means that a Board of Appeals may request the planning board to reconsider a motion. So in the event that you've gone through the application, let's say someone built their house, but the neighbor's not happy about it because they believe that the house is too close to their property and you didn't do your job correctly, that abutter has the right to, within about 45 days, I believe, submit a request to the Board of Appeals or zoning board and say, I don't think that the planning board did their due diligence and I want to argue that. And if the Board of Appeals or zoning board agrees with that individual, the Board of Appeals is going back to the planning board and saying, we want you to reconsider this application. We want you to go through the process again because we believe you may have missed something. You do not necessarily have to agree with the Board of Appeals that night, but if you choose not to act on it, it gives the applicant the ability to then go to Superior Court on the matter. So you don't have to agree with the Board of Appeals, but that then will lead up to Superior Court if the individual does have a case. That's always something to, again, talk to the town attorney about if you start getting to that crossroads. Yep, I figured that was going to get a question.
No, it's my question goes probably a lot more basic than that. It has to do with the Board of Appeals.
Mhm.
who or what or where, or what's the genesis of the Board of Appeals?
So
What, in the reason, let me go back, maybe I can clarify where I'm going with this question.
okay,
This is the first time I've been sitting on a planning board for 3 years, and this is the first time I've ever heard anybody reference a Board of Appeals. And so I'm trying to figure out who that entity is.
so I'll just start by saying that if you've been on the planning board for multiple years and you've never even heard of the Board of Appeals, then you've been doing a great job so far. Congratulations. So, all seriousness. The Board of Appeals is very similar. They are a volunteer group that's appointed by your select board or however the appointment or election is done. And they are sort of the backup when it comes to determining how an ordinance should be reviewed. Actually, Dan, do you want to talk more about the Board of Appeals?
Yeah, a Board of Appeals is essentially the board that, say if you rejected an application, the applicant has the right to then go to the Board of Appeals to attempt to get that rejection overturned.
Can the select board serve in that function?
They
No.
cannot.
No, and actually, that's an important question that I want to repeat, because it's also applicable to the planning board as well. Can someone from the select board be on the Board of Appeals? No. And a member of the select board, nor a spouse of the select board should be on the planning board either. That causes a great conflict of interest and should not be done to your best of your abilities.
Planning board members can't be on the board.
Correct. And planning board members can't be on the Board of Appeals because that's going to look very biased. That the planning board thinks that they did this correctly, and then the one member of the Board of Appeals who's on the planning board says, yeah, no, the planning board did everything correctly. What are you talking about? Same thing with code enforcement officer and any other types of administrative responsibilities. I'm sorry, Dan.
Oh, just when in doubt, if you don't know, whether there's a conflict between a person being in multiple positions, MMA is always well asked.
Maine Municipal Association, great people.
Is the only remedy a legal remedy when in these small towns, you're lucky you can find people with certain boards, and like in our town, for example, there is no board of appeals. So
So,
what happens? Is it only a legal remedy if somebody really wanted to push the matter?
so what's the remedy if there is no Board of Appeals? First thing is probably ask the select board to correct that. Just
Well, they can't get people to-
because if that's not the case, then the matter would go directly to Superior Court because there's no way of addressing this at a local level. Unless, I don't know, well, then again, you
Half
haven't
of our
got,
members of our appeals board don't really even know they're on the appeals board. But we have a major problem in my town. We don't have a code enforcement officer or a local plumbing inspector. And state requires that, but it's an island. Can't get people to do the job, so.
out of,
state can require it all they want, but if you can't find somebody that will, it's a real problem.
yeah, it's always difficult, but there's always got to try and be that push. At least if there's someone out there who might be interested, even if it's someone who's just on there ceremoniously. And to be honest, yeah, you're not going to getting too many Board of Appeals requests. It's only really when it's a high tension case. Like, there's no one here from Belfast, right?
Blue Hill just had a solar.
Blue Hill has a solar farm as well. And then
That's
Rockport had the whole thing with the hotel as well. That went through the zoning board multiple times. Yeah,
No, I was just, you mentioned that you don't have a code enforcement officer or a plumbing inspector. Okay, now, I guess where I'm going with this is what type of liability does the town take on if they don't have these kind of services available? And somebody I'm gonna say somebody builds something that's requires code enforcement or plumbing. What do you do? What happens to the town?
so what liability does the town have if you don't have those positions filled? It really depends on it, and some towns will just reach out to a neighboring community and ask their code enforcement officer or their staff members to try and assist in this matter. But I know I know.
You know, which, yeah, I can understand that, but what I'm saying is, what if something happens that the town doesn't have the ability or has the expertise to provide that oversight and the construction or the plumbing occurs, then what happens as far as,
Th-
does the state come back and
That's,
pounce on the town for not enforcing requirements?
that's all some,
As far as I know, you as a municipality are not strictly required to enforce your code. You could always say there are minimum state standards for code enforcement.
Right.
Then who enforce, I know that's minimum,
so,
that's what we deal with primarily is minimum state standard. But
Right.
if the minimum state standard says the plumbing inspector will verify that the plumbing is good. Or an electrical guy will verify that the homeowner correctly wired his house or whatever this, you know, subsurface wastewater, whatever it is. Is if it doesn't occur, yet a homeowner or a builder
Is doing
actually does something that should have had those kinds of permits or oversight. Where does, who enforces it, and where does the liability for not meeting the requirement fall?
that would be a big question to ask your town attorney at that point. And if it's, and if it's,
Town attorney.
or,
We don't
Emmett,
have an attorney.
if I may, or the Maine Municipal Association, they are a free resource for your communities, so talk with your town, select board chair or town clerk or town administrator. I don't necessarily know what the chain of command is in your community, but I would check with them and say, I have these great concerns. Can we please reach out to MMA to get some clarity on some of these questions? And
What if you don't like the response you give them? I might give you a specific example.
okay,
Okay, let me give you an example of what I'm talking about. This came up in the borough.
okay,
Okay, and hopefully I'm not gonna get anybody in trouble, especially me.
just remember, we're being recorded.
Well, never mind, I'm not gonna ask them.
Usually that comments out.
No, I like an answer to it, but I don't want it recorded.
Okay,
I'm gonna let
I-
that go, because I'm
We
not
can-
gonna, I'm
yeah,
not gonna
I'll just,
implicate myself in anything or implicate
Right,
anybody
I-
else.
I'll just quickly point out as well, we are just trying to cover the basics of everything. If you do have specific questions, I don't mind staying after the meeting or workshop just to quickly go through some of these as well, in case you have some more specific questions, especially ones you don't want to be recorded and uploaded on our websites later. But,
I would second just say MMA is a good thing, so start by asking, email, asking, make your changes.
right. But if, check with the planning board chair or check with the select board chair, whoever the chain of command is in this point, because MMA is going to take a while to respond and they probably don't want to have 20 different questions that are all the same thing. So,
This might be a side note, but in the situation like you're talking about, if you don't have, the town can't get code enforcement officers and such. You may not be able to answer this. Would it be legal for the town to have rulings that says a homeowner, because some homeowners want to just Wild West, do anything
they won't.
themselves? Could a town just have a standard, so to speak, that says your electrical, we need a licensed electrician to sign off. Your plumbing, we need a licensed plumber to sign off. I mean, it's pretty much what a code enforcement officer does, but if the town doesn't have one,
So the question is if the town can have different standards so that you try and have sort of a third party person approve all this instead of a code enforcement officer and local plumbing inspector,
have.
as examples.
A ruling in your town that since we don't have a code enforcement officer and you're gonna build, we need a licensed person to sign off on it.
Mhm.
They're all licensed by the state.
Again, that would first, it would depend on what your ordinance says. If it specifically says you need your code enforcement officer or a local plumbing inspector to do all this stuff, then that's what your ordinance says. That's what has to be done. If you're amending it to remove or change any of that, you would want to check that with the attorney or hire an attorney for a review of that. Because
Is there some minimum state standard?
there are some minimum state standards, and that's why I'm saying you should
Yeah.
check with attorneys on that.
Yeah.
Because I'm saying in the general sense, check with attorney when you're doing such a massive change of shift from who's responsible for doing what. For plumbing and subsurface water, yeah, that's all something there's state code for that. So you'd want to be extra sure that you're addressing all that. So I just want to try and get back through the rest of the slides. Just some reminders. Do not talk privately amongst yourselves, especially during these meetings as well. People are going to be curious why you're quietly chatting with one of your planning board buddies at the very end of the table while there's a very interesting conversation going on. You should always be consistent with your planning board procedures. I go back to talking about how important a checklist is and just having a uniformed agenda for how you conduct all of your meetings. I was actually just at a court case today to argue that we weren't mistreating an individual because we were treating them the same way as we were treating every other applicant that had come through the town that we have dealt with. I always suggest coming about 5 minutes or more early, just so the planning board does start on time. I know that's a bit ironic or hypocritical coming from me who started, what was it, 2 or 3 minutes late? If you know you cannot attend a meeting, notify your chair as soon as possible, even if it's just a few minutes before the meeting. If you have alternative members in your community, the chair would probably want to know that so that they can call the alternative member and get them to attend. And even if it's just a few minutes before the meeting and the chair is sitting down, can't call anyone else, at least give them that notice and say, I can't attend the meeting, because if the chair is just waiting for you to show up, the chair can at least say very early on, so-and-so said that they can't make it, we don't have a quorum, we'll end the meeting, rather than having people wait for someone who will never show up. Make sure you keep the site review focused on the application itself. Again, if a member is providing personal experience, make sure it's relevant to the application. Do not feed into personal arguments. There's going to be heated moments where an abutter is going to argue with the applicants and vice versa. It's very important that you make sure that they don't get to a heated point where you eventually need to call in some help to remove some people. But more importantly, you don't want to be on one of those ends of the arguments where you're starting to argue with the applicant or you're starting to argue with the neighbors, because that might get into an administrative appeal where someone will make a perceived bias claim that, well, of course they didn't approve my application. Did you see how this person yelled at me during the middle of the meeting? And the abutter will say, well, of course they approved the application. Did you see how they treated me during the meeting? So you always want to stay calm and collected during these meetings. And also remember that the planning board is responsible for the approval, not the applicant, nor the members of the public who are attending that meeting. Just because an applicant wants to try and build their house before summer starts, but they decided to wait until 2 days before the contractor was going to get there to contact you, that's not your problem, that's their problem. And if there's someone from the public who just doesn't like the idea that, I don't know, a retail store can be built in a rural part of your town, you follow what the ordinance says. If they don't like it, they got to change the ordinance. And then just a few more suggestions that I want to go over. If you're not happy with the procedures, if you have some concerns or you foresee some problems happening down the line, just like the code enforcement officer plumbing inspector item that was just brought up during the questions answer period, work with the town office to change it, but make sure it follows the state rules to the best of their abilities. And especially as new members of the planning boards, don't be afraid to ask questions to get more information. A lot of the things that slip through the cracks are the things that we all think are just obvious and assumptions. Don't be like that. Just say, you know, this doesn't make sense. Can you please explain this for us? Again, have a checklist to show all applicable standards and help keep track of your process. I'll tell you right now, a checklist has helped reduce some of the meetings I've covered go from about an hour to 45 minutes. It may not seem like much, but dang, 15 minutes out early is pretty nice. You can also adopt a remote policy so that you can provide flexibility to members who have difficulty attending meetings in person. prior to 2020, this was not an allowed item. All planning board members had to be in person at these meetings. But after COVID certainly happened, the state had relaxed this rule with the Freedom of Access Act. So as long as the planning board has an active remote policy that outlines, how people from the general public can attend and how your planning board members are able to attend the meeting, you are allowed to have a remote policy to have this. I think it's always a good backup just because of something like tonight. We have some people who are attending remotely because some of them probably don't want to make the big drive to and from this site. I probably would have joined them if I didn't have to be here in person. No offense to people of Searsmont or anything. It's just, I got an hour drive after this, 80. And again, you can speak with your town attorney if you want some additional input on this. I believe the Maine Municipal Association actually has a model ordinance, or I'm sorry, a model policy on their website if you are interested. But overall, have fun. I'm serious. Have a sense of humor when it comes to these planning board meetings. A lot of people get intimidated by planning board meetings. You're going to feel burnout, but as long as you can be serious in the times you need to get that application reviewed and possibly approved, versus like the introductory moment or going over the minutes or going over an ordinance review, there's no harm in throwing a few jokes out here or there, as long as it's not something that's actually going to have a long-term impact. Like I've used Avery here a few times for some of my jokes. Hopefully I'm not embarrassing you too much. And then just some state rules and standards to keep in mind. I mentioned this earlier, that when you're doing conditions of approval, something like this is likely going to come up. So Department of Transportation, if it's on a state aid road, it does require the DOT to provide a permit. And even if that already has a permit, I don't think it hurts to simply reach out to the Department of Transportation and say, hey, can you confirm whether or not this does need a permit or not? And I always advise that happening to applicants first, because if they can't even get an entrance permit, it's hard for them to do their use or get any traffic on their site. There's also the Department of Inland Fisheries and Wildlife. They provide beginning with habitat maps of your community that shows any wetlands or sensitive habitat areas that should be considered when discussing these developments. I especially use these for areas that are within 250 feet of these wetlands. These might not even be shoreland zone designated areas, but it's good to keep these things in mind, especially with some of the impacts these places can cause. There's also the Department of Environmental Protection and Shoreland Zoning. I believe Chapter 1000 was last updated back in 2015, I believe, but always check with the Maine Department of Environmental Protection. They'll let you know if they have any updates. And I know I'll have the workshop slide in just a moment, but Midcoast Council of Governments and Lincoln County Regional Planning Commission will be doing a shoreland zoning focused workshop in, I believe, early December. That date has not been confirmed yet, but we're going to try and have Colin Clark from the Maine Department of Environmental Protection attending so he can go over some shoreland zoning items as well, in case there's anyone interested. But that'll be in Wisconsin, I believe, so keep that in mind. And speaking of workshops, Avery, do you want to go over what you got cooking in the books?
Yeah, I don't have my notes in front of me, but we've got a comprehensive planning workshop, which I believe is going to be simultaneous with you guys' workshop, so it'll be a busy week.
Yeah.
But this is for all stages of comprehensive planning. I believe we're gonna have someone from the state talk about the Growth Management Act. Our chair who's online is gonna talk about developing, I bet he's the chair, Jim Fisher, who's also the town manager of DRL. He's gonna talk about developing goals, objectives, and strategies. I'm gonna talk a little bit about the public engagement process from start to finish. And then we're gonna have some folks from Stonington talk about the what happens after you finish your comprehensive plan. There we go. We're gonna also have a workshop on ordinance development. We're having someone from Redmond and Winchell come and talk, some folks from one of our municipalities, and then probably someone from the state coming to talk about state resources. And then municipal uses of GIS, which we're still working out, but Tora Johnson with UMaine and Chias is going to come talk about, tools of the trade, small and large, depending on your budget. Jim Fisher is also going to speak again, and then I believe we have a town assessor coming. So yeah, a little bit.
A lot going on there.
Yeah, and we're gonna have more rolling out later in the year, but that's what we've got set so far, so. We will have a remote participation, because I think you guys are a little far away.
Let's see.
Hancock County Planning Commission. Yes.
And then for the Midcoast Council of Governments, at least for the upcoming 2 months, on September 19th, we'll be doing a subdivision workshop with Lincoln County Regional Planning Commission. This will be, I believe, 1 p.m. over in Wiscasset. We had to go with that time because of some conflicting schedule moments, but similar to this workshop, there will be a remote option. We will record the meeting. So if you are unable to drive all the way down to Wiscasset in the middle of the day, or if you have some difficulty attending at all during that moment, just feel free to let us know. We'll let you know about that. On September 21st in Bath, we'll be holding a code-based zoning workshop with special guest Randall RN. He goes over an interesting method of zoning that if you're interested on creating a zoning for your community or want to just change up what you currently have, this might be a very interesting workshop just to listen in on. And October 24th, we're still getting this all set up, but we are going to hold another workshop on potential incentive options that you could use for your ordinance reviews. So we know we all love to have your square footage per dwelling units, but with the community resiliency program, there's some incentives to try and encourage more renewable energy or energy efficiency items, or maybe as a way of encouraging more housing in a way that doesn't interfere with the rural character of some of the communities, or just ways that might help make sense based on some other practices other communities have used. That's all some stuff we're hoping to talk about in those periods. Adi, do you have, we're gonna have like, let's see, there's like 2 more slides, but do you have any workshops
Yeah.
you were gonna mention for anyone in Waldo or
I
anyone?
do. Yeah, we have 2 Waldo County, so these, at least our MCOG ones are for our whole region. We do have 2 county specific ones. One is next week on September 6th. That's gonna be on LD 2003. It'll be specifically tailored towards Waldo County towns that don't have specific zoning or land use ordinances. So how to make sure what you do have complies with LD 2003.
And Hillary Go from the state is gonna be there?
Yeah, and we'll have 2 people from the state there who are basically in charge of that program, and they'll be speaking on that. So feel free to bring whatever ordinances you do have. Yep.
Where will that be? And will that be remote function?
Will it have a remote option? I guess we could do a remote option. It'll be here. And then that's part of our Waldo County planning coordination meeting that we're doing. That's a monthly meeting. And then that'll be our September meeting, and our October meeting is going to be October 26th. And that's gonna be, we're gonna have some people from MEMA here. So Maine's Emergency Management Office. And they're gonna be talking about hazard mitigation planning and working with FEMA. So if you ever need to file anything with FEMA for any sort of damages, like, I don't know if you've had any from the past couple storms, but we'll talk a little bit about that. But also Waldo County is the only county in Maine that's currently not covered by a hazard mitigation plan. And so we're hoping to get a countywide hazard mitigation plan going and apply for funds for that in December. So it's going to be talking a little bit about why we need a hazard mitigation plan and what the advantages are and what that process is like.
Right.
Yeah.
Just real quick, Avery, the workshops you're sponsoring, where are those going to be held?
I was just gonna say, we'll have, I mean, they'll be in Ellsworth, but we'll have a remote participation option as well. And then I'll send Max details, and then we'll figure out how to make sure that all.
Is there any costs associated with these workshops?
As long as your community is a member of one of our organizations, then no.
And if your community is not a member of the organization?
Then we'll talk about that after the meeting. And for the members who are part of one of our, or at least the Midcoast Council of Governments, I can't speak for Hancock County. For Midcoast Council of Governments, we also provide monthly newsletters, and part of those newsletters will be referencing these upcoming workshops so that you can pay attention, so that you're aware of them at least. And it's also going to have recordings and all the documents that we're talking about tonight. Sorry.
Feel free to subscribe to our newsletter as well, if you'd like to. It's right on our website. There's like a bar at the top somewhere.
hcpcme.org.
There you go. Thank you.
And then just summer resources, just a reminder of who you've been talking to tonight. There's the Hancock County Planning Commission. We have Avery right here. Applause would have also been an appropriate thing to do. Thank you. We got one. We got two. There we go. There's also the Maine Municipal Association. We've said it multiple times. They are a great resource. Their legal department is a great item to have if you have any questions on zoning or applications or just procedural matters. And they do host their planning board and board of appeals workshops as well, so that if you want to just learn more about this, if they happen to have it closer to your area, rather than, I think Presque Isle was the most recent one.
They changed the, I just attended it, it was remote only,
It was remote only.
because people aren't going to go to Presque Isle.
I
But they bounce around,
bounce.
sometimes they're remote, sometimes they're in
Yeah.
different parts of the state.
And I think they do those about every 2 months or so, or 3 months. I think they do it every
I
quarter.
think they do it quarterly, more or less.
So you can always attend those meetings. Sorry, you were saying?
No, they just do most of their trainings quarterly.
So if you do want to just learn more about it, go through their courses as well, you're free to do that as well, and just pay. Maine Municipal Association also outlines all the workshops they have on their website without having to log in or anything.
And then they also have building on the massive manual of the planning boards.
Yes. Municipal Association does also have a lot of these resources. That includes the planning board manual that you just mentioned. I mentioned the remote work policy. They have a lot of ordinance draft examples and ordinance models that are great resources for any planning board or town staff to take a look at. And finally, there's Midcoast Council of Governments. Hi. I didn't even have to prompt anyone on that one.
Are you and the Hancock County Planning Commission sort of similar weighted or parallel organizations?
We're a little bit better staffed than we are, but yeah.
No, so the Hancock County Planning Commission and the Midcoast Council of Governments are just regional organizations that get some technical assistance funding from the state, so that we're just providing assistance to the members in our region. So Avery will do whatever she wants to do over in Hancock County and any other towns in your region. Same thing with us. We focused in pretty much in this area and go all the way down to Brunswick and Harpswell if anyone needs assistance. But you can find out more about our organizations going online.
Yeah, but basically the state has designated 10 to 11 regional planning organizations that cover the whole state.
Right.
And so the state assigns us a region pretty much, and we each cover our own region that sometimes is, several counties, and there's a couple examples like Hancock County Planning Commission or Lincoln County Regional Planning Commission that are just one county specifically. But for most other of the regional planning organizations in Maine, they cover a broader region.
Are all these commissions, are they sort of quasi-governmental?
Yes. Yeah, these are quasi-governmental
You guys
groups.
Like nonprofit, I assume.
Right.
Nonprofit.
Yeah,
Yeah.
we're nonprofit, quasi-governmental is what
Right.
we tend to tell people. It's just established by state statute,
Right.
pretty much.
So you'd be the equivalent, because I was gonna ask if there was a Waldo County Planning Commission, but there is.
No,
You guys.
I think there used to be the Midcoast Regional Planning Commission, but that was disbanded, I think in 2019.
2017.
27. No, it wasn't. We'll all check on the dates and times and everything. That would have been like the year I started. But we'll regardless, they're disbanded now. But even I say that so fondly, they're gone now. And even though there's the different regional organizations throughout the entire state of Maine, it doesn't mean we happen to have collaborations like this. This was nice. I like Avery. She's pleasant.
There's no requirement for a town to become a member. There's no statutory requirement that says a town.
No.
No. But usually if you need assistance for something like a comprehensive plan, you would go to whatever the regional organization is for that assistance.
Yeah, and there'd be like, you can't really join like a regional planning organization that doesn't cover your town.
Mhm.
There's Waldo County's a weird one because it's divided between 3 different regional planning organizations, and we were just given Waldo County after. So that's why you probably haven't heard much about us before. This is really the first year that we're working in Waldo County after the demise of
Midcoast.
yeah.
Yeah.
So that's why we've sort of have branched into Waldo County. The state assigned us Waldo County, and I was brought on to be the representative for our expansion into Waldo County since I live here.
Couldn't have asked for anyone better. Well, so with all that, are there any other questions, or these are some emails you can see to get some answers, any comments, anything tonight?
I'll say from afar, thank you. I think it's a vast minefield you walk through, and it's hard to imagine the importance of something like freedom of access until you're pummeled by a group or an individual that make life miserable for you. And so it's very important to document and even keep a log of all those freedom of access requests, keep like the findings of fact or anything else, keep good records, because if you don't, at some point you may find yourself on the wrong side of a lawsuit or just a very long drawn out interaction that you would rather not have. And I know that the Midcoast has had more than its share of those events over the last several decades.
Oh,
and
don't remind me of that.
yeah, and we've, as you said, if you haven't had a Board of Appeals procedure in years, that means the planning board seems, and the code enforcement officer, just as important, have been negotiating through this process pretty well. But once things start to tumble, they can pile on. And so it's really important to avoid that. One thing I was going to mention that I'm trying to pursue in Deer Island with freedom of access is, in most cases, when I get a request, I'm going to try to publish my response on our website and say, okay, everybody gets this information. It's freedom of access. That way you don't end up in a situation where one person's got it and other people go, well, we didn't know about it. And so if you've gone through the process, why not consider putting that information on your website? Then it's just public.
That's a fair point. Thank you, Jim. Any other questions, comments about what we've been discussing tonight?
I guess one more comment. I don't think I heard you mention this. It's just the importance of comprehensive plans and backing up whatever ordinances you do have. So if you have any sort of ordinances that were created when you didn't have a current comprehensive plan, you will, if you're ever taken to court, you will pretty much lose always. They're not really considered legal or have a lot of legal validity unless you have a comprehensive plan. So just something to think about. I think there's maybe some gray area if the ordinance was created when you have a comprehensive plan but amended when you don't. I'm not sure about that one. I think it's always better to.
It's better to just update your comprehensive plan when you hit the 10 years. That's my whole spiel when it comes to, and I'm seeing some popped eyes right there.
Yeah.
Mhm. Yeah.
I do think it's a lot easier if you don't let it fall out of date. We're working with Searsmont now. Just going to be updating their comprehensive plan, and it's technically expires in 2 years.
Hmm.
But it takes about 2 years for it to be up to date, but it's going to be a lot less of a process than some of the other towns that we've worked with because they do have a current updated comprehensive plan, so. Yeah, it's still a lot of work, I know, no one loves comprehensive plans, but
What are you talking about? Everyone loves comprehensive plans just as much as they love just general town government. Too much on that one?
Okay.
Max has been in municipal planning for a very, very long time. And
Oh,
he's trying to
Hold on. Just 6 years. Well, what's this very, very long time thing about? Jeez, hasn't even hit a decade. You think I'm like gonna get a cane or something in a minute?
Well, Max has seen a lot working for the town of Waldeboro, so,
Fun times.
but yeah, we're happy to hang around and ask any off,
Any
Well,
off the
camera
recording
questions.
questions?
Yeah.
But any,
I'll say good night, but thank you very much. It's very interesting.
all right.
Dan.
Have a good night then. All right. Are there any other questions before we conclude tonight? Also fine answering questions about like my perfect Sunday or something.
Bye,
No?
Hilly. Thanks for coming.
All right. Take care and thank you all for watching.